Welcome back to True American History. Today we are deep diving into the United States Constitution. And today we're going to be looking at Article 3 of the Judicial Branch. So before we get started, so you don't miss any future episodes, please hit the subscribe button and always be alerted when we have a new episode out. So let's jump in today. This one's going to be a little bit shorter than our normal ones, but let's go on and jump in here. Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their office during good behavior, and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office. So who is actually in the judicial branch? Well, as we mentioned a second ago, within the Section 1, it states that one Supreme Court, which is the only court that is actually created by the Constitution. Inferior courts or lower federal courts, like district and appellate courts, created by Congress as needed. Now, these are not specific courts that are designated to be created by the Constitution, but it gives Congress the ability and the authority in order to be able to create other federal courts. This design keeps the existence of the judiciary permanent, meaning the Supreme Court will remain permanent according to the Constitution, while letting Congress adjust the details of how many justices and which lower courts there will be, and if there should be others that would be added or removed over time. Now, judges have a tenure and an independence. A life tenure during good behavior. Now, that's a kind of a topic that most people don't really look at when they're looking at the judges. When we're looking at the Supreme Court justices, majority of the time, everybody looks at the fact that they're there for life and that's about it. Well, there is another piece into it of the good behavior. Federal judges keep their jobs unless they are impeached and removed for serious misconduct. They also have salary protection. Congress cannot cut a sitting federal judge's pay. Together, these reduce political pressures and help judges apply the law, not please politicians. This is also a part of the separation of powers and the checks and balances. So historically, as we have mentioned before, Alexander Hamilton has mentioned a few things during the Federalist Papers. And in Federalist number 78, Hamilton wrote, defended the structure outlined within the Constitution. He argued for a strong and independent judiciary as a safeguard against the tyranny of the majority and abuses of the other branches. This section laid the groundwork for judicial review. Although that power was not explicitly stated in Article 3, it was later affirmed in the landmark case Marbury versus Madison in 1803. The Judiciary Act of 1789, passed by the first Congress, established the first system of lower federal courts under this constitutional authority. So as we go through looking at the judicial branch, it is very limited in what the structure shows and how it is to be built. And it is done that way specifically for reasons of being able to adjust over time as needed. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors or public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, and between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, and the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exemptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be as such place or places as the Congress may by law have directed. What cases federal courts can hear, jurisdiction, and how the Supreme Court hears them. The judicial power extends to federal law and U.S. Constitution. It questions the federal question cases. So in other words, if there is a question as to whether it is a federal law or it is against the U.S. Constitution, then the judicial powers have the right to hear this, meaning the Supreme Court. Treaties, ambassadors, and foreign officials. If anything needs to go before a court that is handling something dealing with treaties, and specifically also dealing with ambassadors and foreign officials, it will be heard at the Supreme Court. Admiralty law and maritime law, the laws of the seas. If you do not know what admiralty and maritime law is, I would greatly suggest that you study up on them. We will most likely do a session, an episode on admiralty and maritime law in the future. The U.S. government as a party. So if the U.S. government against another foreign entity, against a state, against a person, so forth, those things would be handled at the federal court and at the highest federal court of the Supreme Court. Disputes between states, between a state and a citizen of another state. This was later limited by the 11th Amendment. Between citizens of different states, diversity, and some state versus foreigners disputes. So in history and historical context, when you had Spain versus Georgia, Spain versus Florida, Mexico versus Texas, Mexico versus California, and a few others in the same aspects. Some of the islands in the Caribbean versus England or the Netherlands and a few others would be in that category. So, why does this matter? It creates a neutral national forum for issues that need uniform answers or that cross state lines, preventing 13, at the time, now 50, different interpretations of the same federal rule. Now, that makes it a whole big difference when you have now 50, but at that particular time, 13 even, different interpretations of a federal rule or law. In this case, you now have a Supreme Court that has one interpretation, and that is the only one that would go through. And it is the Supreme Court of the land of all federal laws. And therefore, when they say it is this, it is this. And that is the final say. Supreme Court, original versus appellate. So an original jurisdiction starts with SCOTUS, or Supreme Court of the United States. It's a narrow slice, mainly cases with ambassadors and disputes where states or a state is a party. Now, the majority of them are appellate jurisdictions, reviews on appeals. Most of this is of the court's work. The court reviews decisions from lower federal courts, where the majority of them have the original jurisdiction within those district federal courts, and certain state court cases raising to federal issues, especially if those state courts end up having a issue where it may cross state lines. It may end up being elevated to a federal issue. There may be a federal aspect to what is going on within this particular case. Just for an example, one that I could see would be if going through a murder case or a espionage case, things of that nature that was specifically for the state, however, had tax issues involved in them, federal tax issues. Now that ends up going up to a federal issue. However, the basis of the entire case was as a state issue. But now there's also these federal issues that have arisen within it as well. Something else that could have been on there is there may have been a foreigner that was involved in all of the case being handled by law of a state laws. However, there was a foreigner, a foreign national that was involved in the case. Now it would go up to the federal issue to be able to be handled between a state and a foreign entity. So those are just a couple of reasons why they would end up needing to escalate it from a certain state court and raise it up to a federal issue. Now, the exceptions and regulations clause. Congress can shape the Supreme Court's appellate jurisdiction, can set procedures, some limits. It's a separation of powers pressure valve. Though how far Congress can go has been debated, and it's widely contested when they try to do some of these things as well. We also see some of these things going on where Congress or particular political parties want to lessen how many judges are on the Supreme Court, or as they like to use the term, pack the court with more people and put more people onto the court. Now, lessening the amount of justices that are on the court can bring down less argument, yes, but at the same time, you don't necessarily have the full balance, possible amongst the five. Or if you end up having more, now you have a greater issue of having even more interpretations or influences and things of that nature that would come in, because the court is supposed to be a neutral court. They're not supposed to have any political affiliations. However, we all know that even the judges will lean left or lean right according to their backgrounds, right or wrong. So a trial by jury and place of trial. Criminal trials, except for impeachment. Now remember, impeachments are only handled in the Senate for trial. Okay? But all criminal trials, except for impeachments, are done by a jury. Trials happen in the state where the crimes was committed, or as Congress directs if outside any state. Now, how can you actually have a crime that is a federal crime or a crime within the United States that is not committed inside any state? Well, we have territories. We have Washington, D.C., that is a district. It's not a state. There's the waters, our waters in the area, although that each state does have a certain jurisdiction out from their shorelines. But beyond that, there's a different story to those. So there are areas in which these crimes could be committed that are outside any state. All right. Section 3, treason. Treason against the United States shall consist only in levying war against them, meaning the United States, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. Now, let's break this down real quick before we continue on. The testimony of 2 witnesses. This is actually biblical, where between 2 witnesses, anything is deemed true. Okay? You must have 2 witnesses to the same overt act, meaning out in the open, not covert, where it is spies like us type thing. It's out in the open. Okay? Or the individual or group is in an open court and confesses, yes, I did this. And it is considered treason. Now, if you do not have all of those thresholds met, that person or persons cannot be tried for treason. They may be tried for other things, depending upon what exactly they did. However, they cannot be tried for treason unless you meet this threshold. 2 witnesses of the same overt act or confession in an open court. Period. There is no additions or anything else like that. I will say that there is some controversy around the testimony of 2 witnesses. Now, there are some that ask, well, what about a recording? If there is a recording of the overt act being committed, whether it be audio or video, or what if the person or persons had written it out on social media, whatever platform that may be? Are any of those considered to be a witness Well, that's kind of the interpretation in which the court has to decide on whether those would be considered a witness or is it merely evidence. That is the conundrum in which we are at today with technology as it continues to develop. So the Congress shall have power to declare the punishment of treason, but not attainder of treason shall work for corruption of blood or forfeiture except during the life of the person attainted. So treason is the only crime actually defined in the Constitution. And you got to remember that there is a very narrow definition and threshold, but it's a high threshold that must be met in order for somebody to be tried and convicted of treason. So again, looking at this, you're looking at levying war against the United States or adhering to U.S. enemies and giving them aid and comfort. You must have the two witnesses of the same overt act or a confession in open court. Now, the punishment rules, Congress decides the punishment, but there is no corruption of blood. What does that mean? What does corruption of blood mean? The government cannot punish your family line or permanently take heirs' property because of your crime. Forfeiture can't outlast the person's life. So once a person is tried, convicted, and sentenced for treason, their family cannot be prosecuted or persecuted for that crime. That person, unless they were involved, but that person is the one that solely takes the punishment. Unless the rest of the family was involved, they have their own treason conviction that they would have to worry about. But at this particular point, if we're talking about one individual, then the rest of the family, the spouse, the kids, the grandkids, and so forth, and the rest of the family tree does not have to worry about having forfeiture of anything, of any of their properties or their time or their person whatsoever. Now, if there is a lien or any kind of holdings on that person's property, whether it be an account, it be physical property, land, whatever that may be, that forfeiture cannot outlast the person's life. So in other words, once that person expires, whether they are executed or they die of old age, then the forfeitures are completed. So why does all this matter? The framers limited treason to prevent governments from weaponizing it against political opponents. It's a very high bar to equal liberty protection. This is the reason why the framers had limited treason so tightly with a very high bar and threshold to meet, but with severe consequences. So as we're looking at this, there is a very definitive understanding of where the judicial branch sits, how they can and cannot operate, what they can and cannot try, and what they can and cannot hear as an appellate, and who must be seen before the Supreme Court if they are involved. And just to review that real quick, we're talking about if there are treaties, ambassadors, and foreign officials, if the U.S. government is a party within the case, and admiralty and maritime laws of the sea when used properly. Also, if any case is brought up to the fact of questioning whether federal law and the U.S. Constitution is in question within this case. And then lastly is dealing with treason. It's a very high threshold, very narrow threshold, but it has severe, severe consequences. So I want to thank you for joining us today. I really appreciate y'all's inclusion of the truth in your lives. And please come back as we continue to dive into the United States Constitution. Next, we'll be looking at Article 4, and we'll be diving into that article. So please come back. Make sure that you can, if you like the episode, hit the like button for us. It really helps. Also, please share with somebody that likes history, that wants to know more. And leave us a comment. If you liked what we are sharing, please leave a comment and let us know. Also, if there's a particular subject that you might want us to be able to look into, please leave us that comment as well. And then, absolutely, if you really want to be able to hear each one of our episodes, please hit that subscribe button so you never miss out on any of our episodes. And we praise God for us being able to be one nation under God. And we thank each and every one of you for coming to learn about true American history. Thank you, and God bless. This episode has been brought to you by Indigo-Enterprises Limited.